Okay, and we are live.
Okay, great. So good afternoon, everyone, and thank you for being here this afternoon. I'm just going to give you a quick advance apology. I am on vacation, so I think I am in a quiet spot and should be able to make it through this meeting without any distractions. But if you hear anything, I apologize in advance, and I'll do my best to make sure that doesn't happen. So with that, we'll call the meeting to order. And as we just confirmed before going on the record, it does appear that we have a quorum. We have, well, I guess we'll have everybody identify themselves just so the record is clear. So obviously this is Judge Baio as the chair. Judge Spader is on the bench right now, but you'll see that he joined, his icon is there, but he is not. And when he's done, if we're still going, he will join us. We are also missing Judge Rohraback and Judge Abrams. And I understand from Becky that Attorney Pocklington is on the record and will hopefully join us once he is done. With that, I'll ask the others to please identify themselves for the record.
Good afternoon, Your Honor. George Jenners with Brock and Scott.
I am Jeff Gentis from Connecticut Fair Housing Center and Yale Law School.
Good afternoon, Jenna Sternberg of Mackey Law.
Good afternoon, Maria Stellato.
Good afternoon, Becky Schmidt from Court Operations.
All right, thank you, everybody. And let me just make a note to myself. Okay, all right, so following through on the agenda, we have the minutes that were circulated by Becky to everybody, the minutes of the last meeting. So I would entertain a motion to approve.
So moved.
So moved, Gentis. Any second?
Seconded.
Nobody? Okay, thank you. Attorney Generous, second. Any discussion? Hearing none, all those in favor?
Aye.
Aye.
All right. Any nays? Any abstentions? All right, so that motion carries. Now moving on to old business, we have a couple things that, well, I'll save the good news for last. But going in order of how they're listed for our old business, we have the property calendar notice. And you'll recall at our last meeting, which was some time ago, because we didn't have a quorum for the last meeting, we had indicated that any suggestions would be sent to Becky to be put together and circulated. And Becky, did we get any?
Attorney Gentis, was that the piece that you had sent? I don't recall.
No, that
I think
was on the
yours
foreclosure. That wasn't that on the
Yeah.
foreclosure standing order, which is our second issue. But I don't think there were any things received specifically to the property calendar notice.
I did
Were
not
there?
receive anything.
Okay. All right. So then, does anyone have anything to add as it relates to that one? Otherwise, I'm going to suggest that if there are any suggestions, they be sent to Becky before the next meeting, since we have nothing to review today. But I'm happy to hear if anybody else has anything to say.
I think if I remember correctly, that was mostly Attorney Pocklington who had input on that. So I don't know if he intended to send that over or not, but I think that was mostly coming from his end, Your Honor.
Thank you very much. So I think you're right about that. So then at this point, we'll kick it over to our next meeting. Hopefully there'll be something to circulate in advance of the next meeting so we can take a look at that. If there's nothing else on that matter, then I'll go to the next one, which is the foreclosure standing order. We wanted to give you an update on that. That was the one that Attorney Gentis put together a list of proposals. We had a discussion about them at the last substantive meeting that we held, and agreed that we would send those recommendations off to Judge Bellis for her review and consideration. Before I go on to tell you what our response was from Judge Bellis, let me just ask you, does anybody have anything to say about the summary that I just provided? Do you think I missed anything or anything needs to be altered in any way? Okay, I see people shaking their heads no, so thank you. We did hear back from Judge Bellis, and Becky, pipe in if you think that I'm not summarizing this sufficiently or I'm missing something. But basically, Judge Bellis's response was she reviewed everything and felt that it was there was no action that she was going to take to modify her foreclosure standing order. Becky, is that a fair summary, or did you have anything to change or add?
Nope, that's a fair summary, Your Honor.
All right. Any questions, folks? I don't know that I'll be able to answer them, but I'm certainly happy to hear them. We did submit them. She did review them, and they were basically not anything that she was inclined to consider. All right. No, I'll take silence as nobody wants to discuss. This is what happens when you have a meeting on the last day of July, right? All right. So the next one, the quality of life suggestions. There's a list of them that are in the minutes from last time, and I was contemplating what we do with them. I know that people had, they're all in there, so I'm not going to belabor them, but there were some things about being sensitive to certain issues and handling things in a certain way. And so other than expressing those as a concern, the question is, what, if any, next step is there? What's the go forward piece of it? And so I wanted to open it up and see if anybody had any suggestions. And I'm going to throw this out there just as something to consider. And hopefully, if you have thoughts, you'll share them as well. I was thinking that we could either take some of those things and put them in a memo form, again, for review and consideration for approval to see if they should be distributed to the judges who are handling foreclosure actions. Or a suggestion that maybe that's the first step, I don't know, that perhaps that be part of some training platform for the judges who are handling foreclosure, something like that. I don't know if that was, but I'll open it up there and ask if anyone has any input. You know what I'm talking about, the things that we discussed that are in the minutes of concerns that were expressed about how to make things better in the foreclosure arena. So does anyone have any thoughts on that?
Your Honor, I'm not sure that this is what you were looking for, but I did send you Attorney Pocklington at our last meeting. I'm not sure if it was necessarily in this section, had discussed the many different ways that the court processes substitution of the plaintiff in foreclosure matters. And he was tasked with drafting something, which he has done, and I'm happy to circulate that for the next meeting if that was the type of thing you were looking for.
Great, thank you very much.
Mm-hmm.
Okay, perfect. And that was on our last issue you're talking about, yes?
Correct, yeah.
Okay, thank you.
And just as
I appreciate that.
Just for your record, I did get an email from Judge Abrams that he is unable to attend today.
Okay, yeah, I had a hunch, but thank you for confirming that. All right. For those of you that don't know, Judge Abrams just had another grandchild, and so he has been otherwise occupied. But moving back onto this one then, does anyone have any thoughts, again, other than just expressing some of the concerns in our meeting here with us of what, if anything, you wanted to see done with that idea of the quality of life issues? Nobody? All right. So I don't want to put anybody on the spot. So we can either, if someone has a thought, if you like the idea of a memo, if you don't, if you want to think about it, tell me that. Again, we can always put this on for the next meeting. There's nothing earth-shattering that has to be taken care of today. But I just want to make sure that I'm hearing from everybody on the committee as far as any concerns about, so things just don't sit here with us and not move forward.
The only thing I can think of is, to the extent that there's an appetite for making some of the notices more plain language, and if there's buy-in from the committee, but also from folks, the AJ and the like, working with maybe a subgroup and legal services to try to make some of the notices that go out, given the number of self-reps in this area, plainer.
Yeah, I think the first step is approval from the judicial administration. So if that's something that folks want to do, what we can do, it seems like, I know there's not a lot of conversation today, but that's at least one good takeaway from it. So we can take that, we can take some of the things that were in the minutes that you had for review for today and sort of bullet point a few things. And I'll ask Becky, I'm sorry to give you more homework, but if we can just circulate, it's basically going to be almost like a copy and paste in bullet form of that section, but that can be circulated to the committee. And if everybody's on board with it, we can hello, Attorney Pocklington, and welcome. We can then talk about seeking approval to do something like that, to see if they're receptive to it. If they're not, then obviously I don't want to have first of all, we're hoping that there won't be a need for subcommittees so much because this committee is so much smaller, that maybe we can do it all together. But in any event, I don't want to make people do work if it's not going to be received in a manner that makes it worth everybody's time. I don't want to waste your time. Everybody's busy. So if it seems like there will be a productive outcome, then I'm happy to do that. Does that make sense? Yes, no, maybe?
Yeah, it does to me. Thank you.
All right. So Attorney Pocklington, we are breezing through the old business, and you came just in time for the good news, which is for the outstanding recommendations. You'll recall that we had submitted, based upon the vote of this committee, we had submitted a couple of recommendations first to Judge Bellis. There's a process. So first to Judge Bellis to determine whether she was receptive to them. And then ultimately, the process is once we get Judge Bellis's approval, it then goes to our Chief Court Administrator. You'll recall at the last meeting, or if you don't recall, you'll see in the minutes, at the last substantive meeting we had, the recommendations were made. This was relating specifically to the clerks entering the virtual space 15 minutes in advance to be there so that people aren't confused, and to take whatever action is necessary to help people out during that time, in particular to the attorneys as well, but also for the self-represented parties, and also to be able to make it easily notable if there is a bankruptcy, like a bankruptcy indicator. We had submitted the requests, we submitted the discussion, the request to Judge Bellis. She came back with a bunch of questions. We responded to those with Becky's assistance. She went back to make certain inquiries that we needed to ask relating to what was permissible within the structure of the clerk's job requirements and various other issues related to that. We provided that information back to her. I'm pleased to report we finally, while she didn't approve everything, she did approve the two things, one of them being the requiring the clerks to enter the space in advance to be available for folks that are entering the virtual courtrooms and to assist them. And the other was we confirmed that Becky was helpful in this. Judge Bellis had noted that there was already a bankruptcy indicator built into this. Is, that Edison stuff. So it's beyond me. It's all the techie stuff that the clerks deal with. But there's already something built in for that. So, but the clerks have to implement it. And so she's authorized us to seek approval, which is the next part of the good news, to have the clerks make sure they use that, to make sure they're all aware of it and that they're using it. And it makes it easier for everybody. We submitted that to our Chief Court Administrator, who has approved those recommendations. So as of today, there's already been a notice that has gone out to court operations to let them know that these recommendations have been accepted and approved by judicial administration. And they have asked Becky to send notice out to the clerks to make sure that they are aware. So at least at the end of our term, we have accomplished something. Becky, please tell me if I missed anything.
You got it all, Your Honor.
So I want to thank everybody here for that, because things move slowly, and I understand that sometimes it takes a while, but I think it's great that before we end this first term, we have had some impact in a positive way. That addresses all of the old business. Unless anybody wanted to comment on anything else, we can move on to new business.
Let's ask, what does the Edison program provide for with the bankruptcy notations?
Becky, you want to explain that flag thing?
So the original request, I think, was one when Judge Morgan was still with the committee, and she wanted something that would bring it to the judge's attention immediately that a case was in a bankruptcy posture. And there's already something built into the system. So there's, it's not a flag per se, but there's a spot within our internal system where we can maintain that indicator. And the practice has just kind of fallen by the wayside, if you will. I think a lot of clerks, we have a lot of turnover, as you know, are unaware that it exists. So what I will be doing is directing the field that is something that needs to happen. And it just gives the judge an easy way to identify that the case is in bankruptcy. And then once the case comes out of bankruptcy, the clerk then goes in. In most cases, it will probably be case flow because we do get notifications when we get a bankruptcy stay or a relief from stay. We'll then go in and take the indicator off. And it's just an easy way for the judge to look to one spot on the screen when they're reviewing a case to see that there's a bankruptcy without having to scroll through the entire, docketing sheet to find it.
Yeah, and it's not just the clerks. It did fall by the wayside with the clerks. I get it, but also to the point where the judges didn't even know, because that's why Judge Morgan made the inquiry. And I think we were all pleasantly surprised to find out that there's an easy fix that just hasn't been used. It will save a lot of time, in particular when some of these cases have gone on for a really long time and they're in and out of bankruptcy. It's helpful to be able to see that. So that's what that one was all about. Anything else, folks, on the old business?
Becky, do you know if it will differentiate between whether the case is open and whether the stay is in place? Because it doesn't always align perfectly.
So the indicator, the way that the staff is meant to use it is that when the stay is in place, the indicator is on the case. When relief from stay has been granted and the case can proceed at the trial court level, they're to remove the indicator.
So there's still going to be issues that come before the judge, but at least it makes it easier to tell what the status is when it's initially being brought. Obviously, there's still going to be issues. People are going to say they filed another bankruptcy or they moved for another stay, and then we'll address that. But it at least helps us to see where things stand when it comes before the court. So anything else on old business, folks? Okay, so do we have any new business? Yes, Attorney Pocklington, thank you.
Unsurprisingly, besides loving the sound of my own voice, I do want to discuss, just very broad brushstrokes, what, if anything, we may want to do or get involved with regarding it is currently still a proposed rule, but the CFPB promulgated legal loss mitigation rule, a proposed rule. The last time they did that was in 2013, and it was frankly a sea change in terms of loan servicing. That's when we all had to sort of take a crash course and learn what dual tracking meant. And with a new, if implemented as currently written, the new proposed rule would also have significant impacts, or at least potentially significant impacts. I'm wondering whether the committee has an appetite for trying to educate on the subject. Obviously, individual judges will rule on the merits of the arguments brought before them. I'm not trying to anticipate that, but just the idea of this is new and this is potentially big, whether it makes sense for us to try to pull together some materials, or I don't want to say analysis, because obviously, even though the practitioners on the committee are well split between which sides we come down, whether there's at least enough of an appetite to factually explain the new rule and sort of have some sort of material that could be distributed amongst the various judges that handle foreclosure, or whether I might even be overstepping just thinking about it.
Anyone want to pipe in?
I mean, to the extent there's an appetite for those, like maybe, it's in connection with the sort of September rotation or assignment for judges who are regularly hearing foreclosure. I mean, it's not unusual in other states for there to be, trainings, and even if they're like done by people from both sides, or, someone who's like an ostensible neutral, it's a normal thing to do. And it's like, you can have a pretty, a substantive but also straightforward, like a neutral, like here are some of the things that you may hear about. And that way it's like it's even if that's done like, every year or every 3 years or something like that, like updates and foreclosure developments or something like that. That's something I would be happy to help with. I'm sure my colleagues outside this committee would be helpful too. And even just things like, we would like a year and a half of having My Home CT, which is like, affected probably, I don't know, 2,000 foreclosure actions in the state, but also was like just kind of comes out of nowhere. And then you're sitting there at foreclosure judgment hearing, applying for My Home CT, which sounds, potentially like a fake program, but it's federally funded. Just having some background or updates might be helpful. But again, it's up to, I don't have a great sense of Superior Court judge. And I'm aware there's annual meetings, but
Okay,
beyond
well,
that,
I can help you on that a little bit.
yeah, sure.
We do have regular, not just our global Connecticut Judges Institute, which is our annual training, but we also have in various practice areas additional training, and there's an annual foreclosure update for the judges that are doing foreclosures. We do have that, and we also do it for housing and other areas as well. So, and that's done through the branch. Judge Spader and I did the foreclosure update 2 years ago. He did it this past year, was shorter. I think he did this one alone last year, right, Becky? I can't remember now. Okay, maybe with one of the mediators might have done it too, but it's done internally. I don't know. It doesn't generally go beyond judicial, so I don't know about a training. Now, that said, I can certainly, from an educational standpoint, submitting information that might be of use for the judicial branch, I can certainly, we can reach out and ask whether that is something that our leadership wants this committee to get involved in or not. I think it probably makes sense to do that again before anybody starts undertaking a job that could take a lot of time and then nothing comes of it. So the other thing is, it may very well be, we might get authorization to actually have one of our meetings be, these are televised, these are broadcast, or not televised, these are broadcast and recorded. So maybe it's something where we can do it in this forum. But if I will ask if everybody wants to pursue seeing whether there's an interest in having that come from this committee in some fashion, I'm happy to at least ask whether that's something that our administration wants us to do as an advisory committee. But I would like to know if we have consensus before I do that. Anyone else want to weigh in?
So, Your Honor, I certainly can't speak to the judge's piece of it because, as you said, it's that's through a different. It's not through court operations, so where we provide staff support and things like that. But I can say, in terms of education, if you will, that for mediation purposes with the foreclosure mediators, we often collaborate when there are big changes, such as what this rule proposes to change, both with the practitioners as well as some other agencies that develop materials, just to kind of meet with the mediators and explain the change in the rules and what the servicing requirements are, because we find obviously it's important for the judges to know, because the judges are ultimately rendering judgment when somebody is in front of them and they have things pending. But we often find that that's the mediation period is where a lot of this is coming into play. So with Attorney Generous's firm and Attorney Pocklington's firm, and then the program manager for foreclosure mediation, there's often discussion, if you will, and things like that, so that everyone is kind of understanding what we're dealing with when we're talking about what the requirements are. So that's my 2 cents for that.
All right, thank you. Mm-hmm. Anyone else? All right, so how do people feel about the suggestion of inquiring whether judicial would like us to put together some sort of educational material relating to this issue for circulation.
I would only amend my suggestion to include, like, to the extent that if there's not an appetite to have practitioners do that, then looking to either even the Bureau itself or some other group, see if they can come in and they'd be willing to present, just so that, well, 3 months ago, we heard from Gendis and Pocklington on it, and now they're fighting with me, or if they're fighting with each other in front of me, that's not what I want. So something like that would be the only, trying to recruit a third party is something I'd be happy to help with as well.
All right. Well, I mean, I have a hunch there will be some, as Becky has indicated with the staff too, some discussion, education to the judges as well. But again, to the extent that this committee wants to be involved, I'm taking that response from Attorney Gendis as being consistent with the idea of consensus. I know what Attorney Pocklington's position is because he's made it known. How do the other folks feel about that? Because I would like, if I don't want to present something and say that the committee has made this suggestion if it's not truly a committee suggestion. So I just want to make sure everybody's on board with it. And if you're not, that's okay. I'd like to hear from you too. All right, how many want to do it?
Personally, I do tend to shockingly side with Attorney Gendis here. I understand trying to provide some clarity here, but I think if something were to come from the committee, it may be slightly more biased in one direction, just based on the makeup of this committee. So I think anything that could be done to come directly from the Consumer Financial Protection Bureau might make more sense, just in terms of being a unbiased third party presenting that information. So I definitely think it's important to make everyone aware of these things, but I just don't know specifically where it should come from.
Okay, fair point. See, that's why we like to hear from people. Anyone else? Attorney Sternberg, Attorney Salato, what do you have to say?
I don't have much to say, unfortunately.
I don't have a strong opinion as either
Okay.
about what the source would be.
Attorney Salato, how about you?
Same here. I don't do much of the mortgage foreclosure end of things, so I don't have much to say one way or the other.
All right. So how about at this point, if on behalf of the committee, I just indicate that there was a suggestion made that this should be brought to the attention of the administration for purposes of making sure that there is some educational and informational session or circulation going out to everybody. And I'll just keep it generic. How's that? All right. You got that, Becky?
I did, Your Honor.
All right.
And if not, I'll listen to the playback.
All right. Thank you. All right. Well, that's that's another good thing though. So that's great. All right. Any other new business?
I just had a question about, I'm sorry, George, you unmuted. Go ahead.
No, mine's going to be very brief, so go right ahead.
I just had a question about how appraisers make the list for the sake of foreclosure sales. Like, how did they get appointed? And it came across because we were doing it different for something that's just totally unrelated, not entirely relevant. We were looking at where the appraisers come from now. And I mean, I was just struck by, like, one of the appraisers that's commonly appointed is from Cranston, Rhode Island. And I would, like, listen, as a Connecticut chauvinist, I would even understand if they were from Foster or Westerly or some border town, but Cranston just seems like we're really, pushing the business out a little too far beyond our borders. And it's also, I mean, and it's relevant not just because they are from Rhode Island, but because, like, the premise of the appraiser, of having an appraiser is somebody who's familiar with the local market. And maybe they are, I don't know, but it came to me, it just was, I'm curious about how the appraiser's making on that list and if it's worth refreshing it or taking a look at it. It's very minor. And this is, again, only like the appraisers who are appointed to help the committee with their conducting a foreclosure sale.
I'm attempting to pull up the information on that. It's done. There are requirements. It's done upon application to the presiding judge in the district. There are requirements they have to make. There's a distinction between residential appraisers, and then there are those who also have worked commercially. So if there's a commercial property, you'll see there's a much smaller list of commercial appraisers. So if you're working with a lot of commercial property, you may see the same appraiser a few times over. But other than that, when an appraiser is appointed, it's whatever list is maintained within the judicial district, it goes in order. So it's not discretionary. The appraisal list is maintained and the next person on the list is utilized unless there's a commercial application. But I'm just looking for the information to get it for you for how an appraiser makes application to the presiding judge.
Yeah, sometimes it is hard to find things on the judicial website. So maybe if you find the link, Becky, maybe you can circulate it. I can tell you that the request to be added doesn't make it, it doesn't happen all the time. Like the people that are on the list, a lot of them have been on there for a long time. I've seen myself personally, maybe only a couple of times where I've been asked to review an appraiser's application. But if you find it, if you want to circulate that would be helpful.
I know it's out there. I just can't get my hands on it.
I know it is too.
I will get it to you after the meeting.
All right, sounds great. No rush. Thank you.
And Attorney Generous.
Yes, I just had one brief thing that a few attorneys in our office had brought up, and I don't know if it's necessarily a problem, but in dealing with a problem, it was determined that the standing orders with regards to the committee reporting the results of the sale, there is no requirement for that. So I believe we had an issue with a committee who wasn't giving us the results of the sale and was giving us a hard time about it. And it took approximately 5 days to get the results of a foreclosure sale, which happened, which we had to report to our client. So I think that the main issue isn't that there are committees who are taking way too long. It's just that there isn't actually anything in the standing orders about when the committee needs to report the results to the plaintiff, assuming the plaintiff's not the successful bidder at the sale. So I don't know if I know we haven't had much success submitting things to Judge Bellis for with regards to the standing orders, but that is one thing that they did ask me to bring up, just because sometimes our clients want results immediately, and if we don't have them, there's nothing we can do other than ask the committee. And occasionally we get a little pushback saying, well, we don't work for you, we work for the court, so we'll get these to you when we feel like getting these to you. So just in terms of sales results reporting, most committees are very good. They usually get them to us either the day of the sale or at least by the next business day, which would be the Monday after the sale. We just have had a few minor issues with committees not reporting the results to us until significantly later. So it causes a bit of a delay.
All right, that's an
And I
interesting
don't know
issue.
if James has had an issue with that at all.
Let's
I
hear.
know this is something that just came up recently, so.
I've had an issue with this actually, an issue with them not reporting the results to me and then also not filing the sale approval within a timely manner. And then same thing of like not reclaiming it. Like I had just had to reclaim a committee's, I just reclaimed it myself because it's been 2 months from the sale. And like, despite numerous requests, it's always like, oh, I'll get to it. Oh, I'll get to it. And I'm like, no, but it needs to be done because we have to do a closing. So I had the same issue that like the committee just, there's no deadline on when they have to do it. So it just seems like a circle.
They don't get
Right,
paid
yeah.
until the thing's approved, right?
Right. So you would
Right.
think they're like
I
dying
think
to
they'd be
get
very,
paid.
very eager to get that done, but apparently that's not the
Yeah.
case sometimes.
James, did you want to pipe in?
It's been my experience that it's more the problem that Maria was pointing out than the one that George was pointing out, but it could just be that coincidentally, I'm not in the loop about a particular couple of committees. I'll be honest, it wouldn't surprise me at all. I'm not shocked to hear we don't work for you because that has come up in other contexts. But ultimately, specifically as to this, there's the standing order form, which is the JDCV 79, doesn't have a lot of the real nitty gritty play by play. I mean, for example, and I'm sure Your Honor has seen this, A lot of committees still don't use the standardized forms that have been provided by the branch, and a lot of committee filings are done as motions per order as opposed to motions for, there just isn't a lot of real procedural step-by-step instructions, so a lot of committees kind of wing it, which it causes all sorts of headaches at various points.
So Attorney Generous, are you making a proposal or?
I suppose based on what I've heard, the proposed standing order would just, and this is strictly with regards to reporting of the sale results, we would just ask that something be put in place to require the committee to report the results of the sale within one business day, which would be the Monday following a foreclosure sale. I don't want to get into any of the other issues with regards to committees, because that's not anything that I was made aware of, but I know that there are issues. The only thing that I was asked to raise is that the standing orders themselves don't actually have a deadline for the committee to report those results. So I was asked to bring that up. I don't know if the next business day is too tight of a requirement. It seems like it should be reasonable based on the fact that the sales are all on Saturdays. So that gives the committee at least until Monday to provide the results of the sale. But if there's some discussion, if someone thinks differently, I'm certainly open to that. But I do think it's reasonable. I just think that not having any sort of standard set kind of lets the committee do it whenever they feel like it. And sometimes we have our clients asking us why we don't have any sales results, and all we can tell them is that we haven't gotten them from the committee yet, and then they want to know why we haven't gotten them, and it kind of goes around in circles, Your Honor. So my only proposal would be that if something can be put in place to require the committee to provide those results within a given period of time, maybe 1 or 2 business days, I think that would be reasonable.
All right. Welcome, Judge Bader. You made it for our last agenda item. So just in the nick of time, we're just wrapping up with a good proposal by Attorney Generous. Does anyone else want to be heard on that? Is that
just so you know, I did hear the proposal as he was making it. I just got off the bench and I had the audio playing on my desk, so I just
no worries. So yeah, so we're on the last agenda item. It's a good suggestion. It's one that's obviously missing. And what you didn't hear, Judge Spader, is that when we gave the summaries of everything under old business, is that we did submit the other proposals regarding the proposed changes to the foreclosure standing orders to Judge Bellis, who had determined that there was no action that was going to be taken on those. That basically the standing orders were not going to be amended, and that she was not accepting any of those changes. This is a new proposal, the one that was not included previously. So Attorney Generous, I don't want to put words in your mouth, but are you essentially making a request that this committee consider making that proposal?
Yes, Your Honor.
All right. And so does anyone want to be heard on that? If we have consensus on it, I'll put it to a vote. I mean, we can do it either way, but all right. So let's do this. We'll do it procedurally in the form of a motion. So I'll treat Attorney Generous's request as a motion. Is there a second?
Second.
All right. And any further discussion? Hearing none. All those in favor?
Aye.
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 Hi.
All right, then I won't ask if there are any nays or abstentions because it looks like it passed unanimously. So we will put a request together, a proposal together to Judge Bellis to indicate the proposal that this change be made to add to the foreclosure standing order. And we will report back at our next meeting what happens.
Your Honor, would you like me to provide some language to Becky? I can email it.
I think Becky would love that.
that would be great. I just want to get the exact language from the attorneys in our office that deal with the post-sale committee motions, exactly what they're looking for, and then I'll provide that over to Becky.
All right, thank you very much for doing that.
Thank
With
you.
that, is there any other new business? Hearing none, I'll entertain a motion to adjourn. Nobody wants
So
to adjourn. We're
moved.
just gonna-
So moved.
All right,
Second.
and thank you. So Judge Spader and Attorney Gentis, all those in favor? All right. Thank you, everybody. Have a great rest of your summer. We'll see you at the next meeting. Becky will circulate something to you all. And if you need to reach us, you know how. All
Thank you.
right.
All right.
Thanks,
Thank you.
everyone. Bye.